Welcome back to this final segment of this law session on the civil justice system in the English legal system. Now, by way of wrapping up, I said to you before the break that we would come back and look at the criticisms, see if they've been justified, and see if 10 years on, Professor Michael Zander has considered things differently. Now, again, he wrote in the New Law Journal. I would urge you to look at it. It's in 2009. It is a good article by virtue of giving sort of feedback on the civil justice system. But if I go through the main points as to what Professor Zander says, he said, when Lord Woolf introduced his reform proposals, he considered that they were given this broad welcome by about everybody, except him, of course. And he said the approval rating remains high. He cannot see why, and that's what he's saying. He said, when I look at this whole uproar and support, I can't imagine why. He said, everybody seemed to have agreed that Lord Woolf's vision of the new litigation landscape has been largely successful, except in relation to cost. He said, but hang on a minute, that doesn't make any sense. Because if you're going to introduce something and from the outset you're looking at reducing costs, how can you say it is successful except for costs? So Professor Zander in this 2009 article says that he was against the proposals from the outset. He spoke out strongly against them with no effect. He said he feared that the proposed reforms would have the opposite effect of what was intended, and he said all it would have done, as I mentioned earlier, was make a bad situation worse. And in his view, at the time of writing in 2009, he says, 10 years on, he believed that the evidence, based on what we're going to go through shortly, he said it shows that on the main issues, his fears that it would make a bad situation worse were actually fully justified. And he considered that given that he is so justified, he simply is at a loss to understand why the Woolf reforms continue to have such a wide approval rating. Now then, he looks at all of the points that were raised, and that's what we're going to just do briefly. And as soon as we get through those, we will look at what Hazel Jen has to say about the ADR procedures, and that, of course, will wrap it up for us today. When you look at, first of all, costs, he said, on costs, Professor Paisner said that there is universal agreement. They have gone up, which is obviously not what was intended. So the idea here is that he says, when you look at the civil procedure rules, the idea was to cut litigation costs, but it hasn't done that. He said the fact that it has gone up is entirely predictable because when you look at this whole early preparation of cases, the early exchange of information between the parties, the more cards on the table from the very beginning, he said you didn't need to be a rocket scientist to see that this was going to cause front loading of costs, meaning that the costs start racking up from early on in the litigation, as opposed to in the old regime where it sort of spread over time. Now, he said when you look at the previous situation, you would see the preparation of the average case that went to trial would tend to take place at a very late stage. So he's saying it's no good making the lawyers the bad guys and saying, well, you have not prepared your paperwork in time. If you do that, then from very early on, everybody can know where they stand. He says, yes, that's rather simplistic because the idea is if lawyers now have to do this from very early on, before they have even decided that they want to actually take it to court, it means that this early preparation affects costs, and that cannot be a good thing. The second thing he attacks in this 2009 paper is delay. He said the Woolf reforms addressed the problem of delay in two main ways. First, it looked at the fast track by allocating the parties a sort of fixed date for trial, 30 or so weeks. Second, the courts would adopt a new stance and would manage the process of litigation. So what you're looking at is case management for the fast track and some sort of heavier case management for the multi-track. Now he said, giving the parties a fixed date for trial at any early stage is a good idea. that has worked well for the fast track, so he concedes that. So, early, great. He said, but did it cut delays? He said, in order to test the question, you would have to look at the figures before Wolf and after Wolf. And he said the figure to look at is not the period to trial from the start of the proceedings, but the period to trial measured from the time that the solicitor first received his instructions. He said the reason is obvious. Since the fast track created a sort of situation where we had a fixed date for trial, the solicitor needs to get his tackle in order before he starts proceedings. Now, he's saying that when you look at what has been studies that have been carried out, he said that overall delay has remained the same when you look at the pre and post Wolf scenario, and it takes approximately about 13 months. But as far as he's concerned, that's exactly what it was taken before Wolf came on board. So by and large, the whole situation to do with delay has not necessarily been addressed. Case management, he said, was the central idea behind the Wolf reforms. He said he took the view that the ills of civil litigation could be ascribed to the way lawyers conducted the case, and that the way to cure this was to transfer responsibility of progressing the case from the lawyers to the judges. And Zander repeats what he said back in 2005. He said, I don't believe Lord Wolf's analysis as it relates to lawyers was correct. He said, I believe what he considers as in analyzing that area is completely faulty. He said, you can't make the lawyers the chief villains. That would be far too simplistic. And he said that when you look at a KPMG Pete Marwick study in 94 on the causes of delay in the High Court and the County Court, it seemed that there were many causes for delays other than lawyers, including, of course, the anatomy of the case, delay caused by the parties themselves, and various external factors. So when you look at it, he said that, of course, was never going to wash. He said inconsistent judicial decisions, which was one of his chief concerns under the Wolf reforms, particularly with using this overriding objective, seems to have also come at a price, because he said when you look, you're looking more or less at a lottery. It depends on which judge you get, who is then going to engage the overriding objectives, and it may mean that judges vary very widely in the way they deal with cases. Now, complexity was something else that Lord Wolf was seeking to resolve. He wanted a simpler system, easier to navigate. But he said, when you look at the rules, he said, when you look at the practice and the practice directions and all of the volumes of the civil procedure rules, he said, it has actually increased by somewhere in the order of 550%. He said the system is changing all the time. The 10 years of the CPR, there have been no fewer than 49 updates. Now, if it was supposed to be less complex, then you've just made it harder, which means people have to use lawyers more now. Now, one area in which he believed that the Wolf reforms may have been beneficial is in regard to the adversary culture. He said this has or seems to have been addressed somewhat, and it seems to have been that the parties more or less are not as adversarial as prior to Wolf. That's not to say that given the culture it is still there. The whole point about Part 36 offers and so on has been helpful. So when we look at what Zander has to say, we see that he's still not happy, and he feels the same way. He said, yes, there's been some minor changes. Question, do the minor changes justify this shift? Most people will say yes. The last point for the day then is we want to look at Hazel Gen and how she has looked at ADR in light of Wolf. Now, Hazel Gen certainly writes articles, loads of them, in respect to this whole area of ADR. Indeed, the points I'm making now are points she made at a Scottish conference in relation to looking at ADR generally. Now, she said that civil justice, since the Wolf reforms, one has to look how useful it has been. And she produced some interesting statistics on civil justice and ADR in England. Now, she said before Wolf, 50 to 83% of defended cases in the county courts were personal injury claims. Overall, at least 75% of cases were within the small claims or fast track financial limit, and in most courts this figure was 85% or more. The higher value of the claim, the higher the value of the claim, the more likely both sides were to have legal representation. She said PI cases had high settlement rates and a small number of trials. Non-PI cases had a higher proportion of trials and a much higher proportion of cases withdrawn. She said death cases were most likely to end in trials, 38%, and in all of those, the claimant succeeded. Now, in 96% of all cases going to trial, the claimant was successful. She said in all types of cases, 50% of awards or settlement were for £1,000 to £5,000, and a further 25 to 33% were £5,000 to £10,000, and costs in non-PI cases were relatively modest and were maybe around 50% at cost of £2,000 or less. That was the background, she said. She said, when you look at the impact of the Wolf reform, Lord Woolf's approach to reform was to encourage the early settlement of disputes through a combination of pre-action protocols, active case management, cost penalties, and ADR. Now, when you look at the evidence, she says, it does indicate that the Wolf reforms are working to the extent that pre-action protocols are promoting settlements before application is made to the court. Most cases are settling earlier. Fewer cases are settling at the door of the court. In fact, most cases are now settled without a hearing. However, she says, costs have increased, or at the very least have been front-loaded. So when you look at the whole landscape, we do see even persons who thought that the ADR situation was good do consider that the costs and the front loading of the costs is a problem. Now, as to the role of ADR, she says that it does encourage the settlement. It has not increased in the way that it was anticipated. And when you look at the voluntary pilot mediation scheme, which was carried out at the Central London County Court, it had only had a take-up rate of 4% before 1999, and between 1999 and 2003, when the effect of the Wolf reform was beginning to be felt, there was an increase in the take-up of the scheme, but a decrease in the settlement rates from 62% to 40%. And her hypothesis is that the Wolf reforms had led parties to mediate in order to avoid cost penalties and in order to appear to cooperate with judicial direction, but they had only done so half-heartedly in their attempt to negotiate settlements. Now, a reason given by both lawyers and parties involved support this theory. So the point for you then, of course, is to look at what operated before Wolf, what operated after. Look at the criticisms, look at the persons who've actively considered the research and the empirical studies done in relation to this, and certainly anything from Michael Zander and Hazel Gen, I would urge you to have a look at, because the point is that when you look at resolution as it relates to ADR, what Hazel Gen is saying is that it is actually worse off under Wolf by statistically. Now, it may not be worse off in actuality, because persons who were settling before may very well be settling now. But because the pool is now bigger, because of the cost implications, more people are going into the ADR framework, meaning that the percentages are higher when it comes to actually persons not settling. That, of course, brings us to the end of this civil justice law session, and indeed, I would urge you to carry out the further research that you would need in this area.